common query of every student studying law is, ma'am, how to write the answer. We don't know how to frame the answer. We don't know what format is to be followed. So in today's session, I am going to discuss the answer writing format and also how you can, train yourself to frame the answer. See, I totally understand that you may be watching this video, even before you have started studying the entire subject properly. But we are discussing questions relating to Partnership Act. I'm very sure that you must have studied partnership accounts in 12th standard, yes, or you may have studied in foundation itself before you actually watch the lectures for law. So this is not a very new act for you. Yes. So what we are going to discuss through this video, we are not only going to discuss all the compiler questions, but I am also going to show you how you are supposed to frame the answer. Okay, what should be your thought process? How to arrive at the answers, whether it is a theory question or a case-based question, how you can frame the answers, how to actually use the compiler. So students, just to give you a quick recap, first you will watch the lectures. Yes, that is our step number 1. Step number 1 is to watch the lectures. Step number 2, what is step number 2? After we watch the lectures, you will learn the theory from my textbook. Learning is important. Learn the theory from my textbook. Step number 3, solve the compiler on your own. I will train you how to solve it. Okay, through this video, we are also going to learn how to solve it. Once you solve it on your own, then you will watch the compiler question discussion. Okay, so what is our step 1? This is just a recall of what we have discussed. Step 1 is to watch the lectures. During the lectures, we have discussed how to make charts. I have also given you charts to simplify the concept. Watch the lectures. Step 2 is you will learn the notes. Okay, you will learn my textbook. You will learn my textbook. You have to learn it. How will you learn? That I have discussed separately. Step 3, you will solve compiler on your own. Then step 4, you will watch the compiler question discussion. And step 5 is you will solve the test paper. Only after you solve, only after you're done with it, then you will proceed to the next chapter. I hope it is clear. Yes? Okay. So students, let us learn how to solve the questions on your own. Mr. XU and YU. Okay, they are partners in a partnership firm. XU introduced MU, an employee. Okay, MU is just an employee. He introduced MU as a partner. ZU. He is a third party. MU remained silent. Now you are allowing yourself to be represented as a partner. Immediately in your mind, it should click that they are talking about, immediately in your mind, it should click that the concept which they are discussing is partner by estoppel. So see, by reading 2 or 3 sentences, I will come to know that they are talking about partner by estoppel. So see, that is how I need to quickly analyze the question. Okay, partner by estoppel. So this is my first finding. I will keep on writing whatever I find. So partner by estoppel. Now ZU, he is a trader. Believing that MU is a partner, he supplied 50 laptops to the firm on credit. So the third party supplied goods on credit thinking that MU is a partner. After the expiry of the credit period, ZU did not get the amount of the laptop sold to the partnership firm. ZU filed a case against XU and MU. Okay. So is MU liable for this purpose? Is he liable just as a partner? Yes, he is liable as a partner by estoppel. Estoppel means he is not actually a partner, but he is considered just like a partner only for this transaction. It does not mean that he becomes a partner for life. For this transaction, he is considered just like a partner. He is partner by estoppel. So will he be liable to the third party? Yes. Now we know that this is the theory which is discussed in which is applicable in this question. But how to frame the answer? So the first thing is that you need to identify that they are talking about partner by estoppel. Only then you will come to know what theory you're supposed to write. So the first theory, I'll just erase this. I hope you have written the steps. Yes, these are the steps in which you need to frame your answer. Now, how to frame the answer? See, I have given you space over here. Okay, this is blank. All right, this is blank. So you're supposed to frame your answers over here. Just write down pointers. Okay, just write down pointers. So first thing that we will write is partner by estoppel. Section 28. Okay, I will explain the entire concept of partner by estoppel. That is what I need to write. So what all points will you cover in partner by estoppel? That the person either actively represents himself to be a partner, so there is active representation. The person himself says that I am a partner, or he allows himself to be represented as a partner. That is known as tacit representation. So I either allow myself to be represented as a partner, or I am only saying I am a partner, I am a partner. Whether it is active or tacit representation, okay, the third party on the basis of this gives credit to the firm. So then the third party gives credit to the firm. This is the theory that I need to write for partner by estoppel. So did you understand? I first try to recall section 28. Then I read that, then I wrote everything about partner by estoppel. So estoppel means person is either actively telling that he is a partner, or he is allowing himself to be represented as a partner. It may be either active or tacit representation. And on the basis of this representation, the third party is giving credit to the firm. So in this case, even though the person is not actually a partner, for this transaction, he is considered just like a partner. He is partner by estoppel. So for this transaction, he is considered as a partner. He is considered as partner by estoppel. So this is the theory that I tried to recall and see how I made notes for myself. Now, in this case, by applying the above provisions, MU, he allowed himself to be represented as a partner. He is considered as partner by estoppel. Okay, he allowed himself to be considered as a partner. You can also write that this is tacit representation. Okay, you can also say that this is tacit representation. He allowed himself to be represented as a partner. He is considered as partner by estoppel. And on the basis of this representation, the third party has given credit to the firm. So he is considered as partner by estoppel. MU shall be liable. Now this is how I tried to frame the answers. Now you need not write all the answers and practice. Such kind of note is also sufficient. Okay. Now let us see whether I have covered everything from the model answer. In case I miss any point, I will highlight and write that in red. It will be a constant reminder for me that I did not write that point. So let's see if I have covered everything. Section 28, person is said to be a partner by estoppel or holding out. If he himself represents that I am a partner, he represents himself by words spoken or written, active representation, or he knowingly allows himself to be represented as a partner. This is tacit representation. And on the basis of this representation, the other person has given credit to the firm. So even though he is not a partner, he becomes a partner. He is liable by applying the principle of estoppel or holding out. I think I have covered everything. The only thing that I missed was he represented himself to be a partner by words spoken or written. I did not write this point, so I will write it in red. It is a constant reminder to me that I missed this point. And the other person gave credit, so he is partner by estoppel. All right. So in this case, when MU was introduced as a partner, he remains silent. Then he is also liable for price. He becomes as a partner by holding out. Even though he is not a partner, he becomes responsible to the outsider as partner by estoppel or partner by holding out. So MU is liable for the price. I think I have covered all the points. Yes. Let me check. So over here, he is active or tacit representation. Third party has given credit to the firm. Then he is considered like a partner. He is partner by estoppel. He allowed himself to be represented as a partner. Third party gave credit. He is liable as a partner by estoppel. I have covered all the points. If this is asked in the exam, it will be mostly a 4 to 5 mark question. And I think this much is sufficient. Yes. Now, if I have covered all the points, I can expect good marks. In case I miss 1 or 2 points, then they will obviously deduct marks. So try and include all the points today. So this is how I will write and practice. I will write pointers and then check my answer with the model answer. How to frame the answer? You will frame it in 4 parts, that is provisions, facts, analysis and conclusion. In provisions, I will write the theory. This I can write in my own words. Over here, I will provide some solution, and in conclusion, I will write 1 or 3. I have discussed the answer writing format separately. Please try to follow this format in every question. Okay. So students, this is how you will solve the question. Let us now proceed. Now please highlight this as important for exam, because there are many questions which are asked on section 28, that is partner by estoppel. So this is one section which I need to go through one day before the exam. Okay, these are the sections which I need to go through one day before the exam, section 28. It is frequently asked. You will realize when we go through all the questions that many questions have been asked on section 28. Miss Lucy, while drafting a partnership deed, taken few care of, deed needs to take care. I don't know how they have framed the question. What are those points that she needs to take care of? She wants to know the list of information which must be a part of the partnership deed. Also give a list of information to be included in the partnership deed. So what are the things that she needs to take care of so that it is a part of the partnership deed? You need to give a list. So what are things that she needs to take care of? It can be in writing. Yes, partnership deed can be either, so deed can be either in writing or it can be oral. Writing is preferred to avoid disputes. Okay. The agreement is known as the partnership deed. It should be drafted with care and it must also be stamped. Okay, it must be drafted with care and it must be stamped. In case I wish to change any terms, then I need the consent of all partners. Okay. What all will it include? Name of the partners. Okay, I'll write. I don't think I need to write this. Name of the partners, name of the firm, registered office of the firm, the place of business or the proposed business, the date of commencement of the partnership, then capital contribution or the profit sharing ratio, interest on capital, interest on drawing, salary, remuneration, commission, provisions for valuation of goodwill, dissolution, retirement of a partner. So name of all the partners, nature and place of business. Don't use these bullet points. Just write A, B, C. Okay. Duration, capital contribution, PSR, provisions relating to admission, retirement, rate of interest on capital, settlement of accounts, salary, commission, remuneration, provisions relating to expulsion. You may either add or delete depending upon the needs of the company. So that is our advice. So let us see if we have covered everything in the theory. So there is no particular formality required. This I did not include. So I will highlight this. This was not included. So there is no formality required. It can be either oral or in writing. Okay, so it may be in writing or it may be oral. That I covered. Yes, I have covered this. This is known as a partnership deed. It must be drafted with care. It must be stamped. And these are the provisions. This is one extra point which even if you don't write in the exam, it is okay. If it consists of immovable property, the instrument must be in writing, stamped and registered under the Registration Act. This I think we had already discussed earlier also in Contract Act, that in case of immovable property, the agreement must be in writing, it must be stamped and registered. Like immovable property, you want to sell this flat, it must be in writing. This we have covered in Contract Act. Information that can be included, this if asked in the exam, it will be somewhere around 4 marks to 5 mark question. So please manage the length accordingly. I have discussed the length that you need to follow. Okay, so I have covered most of the points. Next we have Master X was introduced to the benefits of the firm with the consent of all the partners. Okay, so introduction of a partner anyways requires consent of all the partners. You can admit a partner only with the consent of all the partners. Here we are trying to introduce a minor as a partner. So yes, we need the consent of all the partners. Okay, after attaining majority, more than 6 months have elapsed and he failed to give a public notice whether he wants to continue as a member or not. Later on, Mr. L, a supplier of material to Messrs. ABC, filed a suit against the firm for recovery of debt. In light of the Indian Partnership Act, explain to what extent X will be liable if he failed to give public notice after attaining majority, and can L recover his debt from X. Alright, so this relates to minor as a partner. This is covered under section 30 of the Partnership Act. So the first thing that I identified was section 30 because that is what I should try to recall. It is okay if you don't write the subset. So as per section 30, let us try to recall the provisions. Can a minor be admitted? Yes. So a minor can be admitted as a partner provided these conditions are satisfied. What is the first condition? We need the consent of all partners. Yes, we need consent of all the partners. What else? He can be admitted only for the benefits of the firm. Minor can be admitted as a partner only in an existing firm. Students, I will not do this exercise for you every time, okay? Because otherwise you will not think on your own. You will get used to this spoon feeding. Then when the time comes, you will again not be able to frame the answer. So this is only to teach you how to write the answers properly. So don't expect that I am going to discuss everything in such detail. Otherwise, you will become dumb. You will not think only on your own. And I don't want to do that. You are all smart students. and you are capable of doing it. I trust you. I have full confidence in you. Please follow this technique, but don't expect spoon feeding. Huh? Okay. So he can be admitted with the consent of all the partners for the benefits of the firm. It means that he will be liable only to the extent of his share in profit and property. It means it is limited liability, and he can be admitted only in an existing firm. You cannot form a partnership with a minor. Minor can be admitted only in an existing firm. Okay. Now, if minor turns major, okay, if minor turns major, then within 6 months he has to decide, okay, within 6 months he has to decide whether he wants to continue as a partner or not. Whatever is his decision, he has to give public notice. Okay, he has to give public notice of his decision. If he fails to give public notice, then we will assume that he wants to continue as partner. Okay, so we will assume that he wants to continue as partner. What will happen? In that case, now he will start, earlier also he was liable, but now he will start being personally liable. Okay, he will start being personally liable for all acts done right from his date of admission. Okay, so in case he fails, then he will be liable for all the acts done right from the date of his admission, whatever is his outstanding. So that we had discussed during the lectures. Now, at any time within 6 months, or the or him obtaining knowledge that he had been admitted to the benefits of the firm, whichever is later, the person has to give a public notice whether he wants to become a partner or he has elected not to be a partner, and this public notice will be given. If he fails to give a public notice, then he shall be deemed to be a partner on the expiry of those 6 months. So yes, more or less I have covered all the points. This is how he can be admitted. And in case he turns major, within 6 months he has to decide and he has to give public notice of his decision. Otherwise, we will assume that he has continued to be a partner. When he becomes a partner, he will now become personally liable. See, I covered that point. He is personally liable for all the acts of the firm right from the time he was admitted. Okay, for acts done right from the time of his admission. His share in the profit and property will remain the same. I knew this point, but I didn't write it, so I will write it in red. His share in profit and property will remain the, okay, that he was as a minor, similar to that when he was a minor. So see, I covered these points. Although this was in my mind, I forgot to write. I wrote it in red. So now I will remember that I missed this point. Okay. So in this case, if he failed to give a public notice, then we will assume that he has become a partner and he will be personally liable to the third party. This is important, that he is personally liable. It is the key word. What was the second question? Can L recover the debt from X? Yes. Since he failed to give a public notice, he will be, and he has not elected not to become a partner, then he will be deemed to be a partner on the expiry of the 6 months. Okay. So yes, we can recover because now he is considered just like any other full-fledged partner. Okay. So now over here, minor has become a major. He failed to give public notice, failed to give public notice. So after 6 months, he will be considered just like a full-fledged partner. So this will help me during revision time. Even if I don't read all this, I know what to read. So I will be able to cover everything. Minor is again important for exam. So write over here minor. Okay, so these are important concepts. Minor. Okay, minor is important. PQRS, they are partners of the firm which deals in trading of washing machines of various brands. Due to the conflict of views between the partners, P and Q decided to leave the firm. They started a competing business in the name of Messrs. PQ and Company. So PQRS, I will make notes while reading the question. They are partners in a partnership firm. Due to conflict, P and Q, they decided to leave the firm. Okay, they left the firm and they started a competing business. RNSF continued and in the old name only. Based on the above, you have to decide the right of P and Q to start competing business and the right of P and Q regarding their share in the property. This is section 36 and this is section 37. Please highlight this question as important. Go through this question one day before the exam. Okay. One day before exam. So write off, this is actually a theory question. It is just framed like a case based. Can a partner start competing business? Yes, he can start a competing business, but he has to make 3 promises. He will not use the firm's name. He will not represent himself as carrying on the business of the firm. And he will not solicit our old customers. Solicit means he will not attract our old customers. If he makes these promises, then yes, you can start a competing business. So you will not use the firm. We had discussed this when we were discussing the theory. Without using the firm's name, without representing yourself to be a partner, you cannot say, I'm still a partner of that old firm. You will promise not to steal our customers, attract our customers. You cannot tell the customers that the firm is selling it to you for 100, I will give it to you for 80 rupees, buy from me. If you make these 3 promises, then I will allow you to start a competing business. Right of outgoing partner to share the subsequent profit. Now see, outgoing will include a partner who has retired or deceased. Deceased means one who has died. Okay. So if the partner has retired or he has deceased, so law says that you need to settle his account. If you don't, then you either pay him the interest on that amount at 6% per annum or you give him the share of profit on whatever amount you are utilizing, whatever you have not settled. So if the surviving partner, without any final settlement of accounts, okay, without any final settlement, they continue to utilize the money is still with the firm, then the outgoing partner, now this outgoing partner may include retired partner or legal representative of a deceased partner. Deceased means someone who has died. They have the right to share in profit made since he ceased to be a partner, and or you give him interest at the rate of 6% per annum. See, for this amount, the partner is considered, it is considered as if that partner has given loan to the firm. So we need to settle 10 lakh rupees. We managed to settle only 2 lakhs. 8 lakhs is still in the firm. We are still utilizing 8 lakhs. So if you have not settled this amount, okay, if this is not settled, law says you give him his share of profit on this amount, whatever is proportionate on this amount, you give it to him. Or you give him interest at the rate of 6% per annum. Ma'am, I want to give 10% interest. No problem. Write it in the deed and you can give 10%. So here P and Q, they are entitled to receive either share on profit on this amount or interest at the rate of 6% per annum. So this is a theory question. It's just framed like a case based. This will, if asked, it will be for 4 to 5 marks. So 2 or 2.5 marks for each, okay, depending, 2.5 marks. X and Y, they are partners. X introduced a manager as a partner. Okay, X and Y, they are partners, but X introduced A, who is a manager. We introduced him like a partner. Oh, A remained silent. Z, a trader, believing that A is also a partner, agreed to give goods on credit. Are we discussed this? Yes, try to recall the section number. Section 28. Partner by estoppel. Yes, section 28. Partner by estoppel. So I don't think I need to write everything because it is same as the first question. But I still recall section 28. Yes. Will he succeed? Yes, he will succeed. Same logic. What do you mean by partnership for a fixed period of time? So this is just a short note. Can a minor become a partner? Explain the rights of minor as a partner. What is the section number? Section 30. Yes. So partnership for a fixed period. Now, this is just a small question. So see the length of the answer. It is very small. Okay? It is just for 2 marks. What is partnership for a fixed period? Yes, we have admitted a person as a partner only for a fixed. The partnership is formed only for a fixed period of time. So let's say that X and Y, they have started a partnership business and they have agreed that we will be in this business only for 2 years. Then let's see if we want to continue, we'll see. So when the partnership is formed for only a fixed period of time, it is known as partnership for a fixed period. When 2 years get over, my partnership will come to an end. Ma'am, but the business has not come to an end. Doesn't matter. As soon as 2 years are over, my partnership will come to an end. But ma'am, we want to continue even after the expiry of 2 years. Then in that case, if you still continue, you will be considered as, it will be considered as partnership at will. Ma'am, I did business for 6 months, but I realized that I cannot do business with Y. It is just not possible. Then in that case, you can dissolve the partnership even before the expiry of the period with the mutual consent of both the partners. When a provision is made for the duration of the partnership, it is known as partnership for a fixed period. It is a partnership which is created for a particular period of time. The partnership comes to an end on the expiry of the fixed period. I gave you more points. They have not written all that. You can write it. So over here, partnership ends when the period ends. Your business or the transactions may not have come to an end. Okay. If I want to continue, then it will be considered as partnership at will. If I want to dissolve before the time ends, then I can do so with the consent of all the partners. Next, they have asked us to define minor as a partner. Try to recall. Minor is not competent to enter into partnership because partnership is the result of an agreement. But I had written it earlier. With the consent of, write along with me, come on. With the consent of all the partners. See how I am writing and practicing. How I am writing and trying to frame my answer. I am trying to revise. I am trying to recall. With the consent of all the partners. Then what is the second requirement? He may be admitted only for the benefits of the firm. Okay, with the consent of all the partners, he may be admitted for the benefits of the firm. And he can be admitted only in an existing firm. It means that I cannot form a partnership with a minor. Minor can be admitted only in an existing firm. Okay. Now, he is a minor. So what are the rights that he will have? Yes, he has a right to share the profits and property, yes, in whatever is the agreed ratio. He can also have access to and inspect also. He has access means he can go through and he can also inspect the books of accounts, then other accounts, not books but other accounts. He can also have the right to take copies of the accounts, but he does not have right to books except the account books. He cannot go through any other book. This is basically to keep the secrets of the firm intact. He can also file a case. He can sue if he is not given his share in the profit. He can also sue if he is not given his share in the profit. On attaining majority within 6 months, he will have to decide whether he wants to become a partner or not. Whatever is his decision, he will have to give a public notice. If he elects to become a partner, then he will get a share to whatever he was entitled. It means share in profit, property is going to remain the same. Only thing is now he will be personally liable. But if he elects not to become a partner, then in that case, your liability will remain as of a minor up to the date of public notice. You will not be liable for the firm after the public notice. The firm is not liable for your acts after the date of public notice. This is how I tried to recall all the concepts. It's a theory question. You have to write it in point format only. Partner indeed is both principal as well as agent. You have to discuss. So you need to write everything about mutual agency. Okay, this we will discuss when we study the concept. Yes, I don't know when you are watching this discussion video, whether it is earlier or later. But in the beginning only students have this query, ma'am, how to write answers, how to write answers. But you will be able to write answers. So you will be able to write the answers only when you study, no? But they want to know that in the first place itself. So I thought I'll put this video before only. I have also done a video on contract act just to give you an idea so that you know how to write the answers. Okay? So your mutual agency. So what will you write in mutual agency? So the person is principal. I'll not use red because red means I was not able to recall. No? Mutual agency person is principal as well as agent. So as a principal, he is bound, not red. Okay. As a principal, he is bound. As an agent, he can bind the other partner. Yes. So this is the concept of mutual agency. So you can also write an example. Okay. The partner is agent as well as business of the firm. As per section 4, it means they have mentioned the definition. Partnership is the relation between two or more persons, because there is not much to write. So we can start by writing the definition. Partnership is a relation between two or more persons who have agreed to share the profits of the business carried on by all or any one of them acting for all. The definition clearly suggests that partner can be the agent of others. So this you can write in your own words. This I think will be too complicated for you to learn. You can just write down that as an agent, he can bind the other partners by his act, and as a principal, he is bound by the act of the other partners. Example, X, Y, Z, they are partners. X borrowed 10,000 rupees from A. In case he fails, then Y and Z are also liable. It means X can, by his act, bind the other partners. And what if Z purchased goods worth rupees 1,000 from P? If he is not able to pay, then X will be liable. Okay, so X is bound by the act of other partners. This is the concept of mutual agents. The principal distinction is that there is community of interest. This is slightly complicated to remember. So you can write in your own words the way I have explained. Ma'am, will they give us marks? Of course they will give you marks. What is the conclusive evidence of partnership? It is nothing but mutual agency. What are the circumstances wherein partnership is not considered? It means there is sharing of profit, but they are not considered as partners. Okay, there is sharing of profit, but they are not considered as partners because there is no mutual agency. Please highlight this as very important for exam. Okay, this is very important for exam. You need to learn this. So what all will you write? Tell me. What all will you write over here? Is sharing of profit a conclusive evidence? So let's see how we are trying to recall and frame the answer. So sharing of profit. Oh, why do I always use red? Sharing of profit is not a conclusive evidence of. Ma'am, do we have to write so much in detail? Yes, otherwise how will you learn the words? It is not a conclusive evidence of existence of partnership. Okay, so sharing of profit is not a conclusive evidence of existence of partnership because we may share the profits with employee also. That doesn't mean that he has become a partner. Okay, when one person is entitled to the entire profit and when he gives salary to the other person, are they partners? They are not partners. So what is the true test of partnership? True test of partnership is mutual agency. This is the conclusive evidence of existence of partnership. I'm writing in short. Okay, so this much is sufficient for introduction. This is how I try to recall. Let's check if I have covered all the points. The cardinal principle, cardinal means most important. The cardinal principle is mutual agency. Mutual agency is the conclusive evidence. I wrote this. So each partner is principal as well as agent. Okay, then I think they want us to write what is mutual agency. Mutual agency means each partner is principal as well as agent. As a principal, he is bound by the act of others. As an agent, he can bind the others by his act. Okay, this they have written. This I did not mention. Okay, so I wrote it in red. So if there is mutual agency, they are partners, otherwise not. Now, what are the circumstances wherein partnership is not considered? There is sharing of profit, but they are not partners. So I think they have written some very vague points. This is not in your syllabus also. There is no record. They have not retained any record. Okay. Partnership has maintained no accounts of its own. No account of partnership was opened with any bank. No written intimation was given to the deputy director of procurement. This I don't know. It's not something which is very commonly known. I don't think this is there in your syllabus also. So just go through it, but I don't think it will be asked. It has been asked twice, but it's not expressly given. Okay. So partners have not retained any record of the terms and conditions of partnership. There's no account of it, so I think it's given in the module, so that is why they have framed a question. So yes, it must be given module, but not something which is very frequently tested in the exam. They have given it in RTP and once it was asked in form. So just one time it has been asked. It does not have any record. They have not maintained any accounts. There's no written intimation. So it means we don't know whether it does exist or not. When you have not opened any account, you're not doing business, no? There's no record that is maintained. Partner indeed embraces the character of both principal and agent. Oh my god, this has been asked so many times. We need to write down. Make a note of it. See how I'm making a note of it. That this is very frequently asked. Minor, partner by estoppel, and partner is principal as well as agent. This has been so frequently asked in the exam. So see how while going through the compiler, I make a note of the questions which are frequently asked. So I don't think I'm going to write it again because we have discussed it many times that partner is principal as well as agent. This is mutual agency. If you feel that this is slightly tricky, we cannot learn it, you can write it in your own words, but explain the concept properly. Okay, what is partnership at will and what is a particular partnership? Partnership at will, it means that the duration of partnership is not mentioned. Okay, they have not mentioned the duration of the partnership. We don't know till when it is going to continue. No provision is made as to the determination of partnership. It will continue till it is wound up. Any partner can, by just giving a notice in writing, okay, you need to give a notice in writing showing your intention to retire or dissolve the firm. Okay, so can I say that in this case duration is not mentioned? It will continue till it is dissolved. And how do you dissolve? You give a notice in writing of the partner of his intention to dissolve the firm. Now the partner has given a notice. He cannot withdraw it unless and until, okay, he cannot withdraw this notice unless and until it is consented to by all the partners. So partnership at will, what are the key points? No fixed period has been decided as the duration. Partnership may be dissolved by any partner by giving a notice in writing of his intention to dissolve the firm. If he wants to withdraw that, then he needs the consent of all the partners. What is particular partnership? Particular partnership means it is formed for a particular venture. Formed for a particular venture. Okay, so it will end when the venture is over. Okay, when the venture ends. But if I want to dissolve it even before that, then I need the consent of all the partners. Okay, in case I wish to dissolve it, then I need the consent of all the partners. So it is formed for a particular venture. So when a particular venture or undertaking, venture, what is the meaning of venture? Venture means project. For a particular project, like construction of a flyover. It is for a single venture, it is dissolved on the completion of the venture. But if I want to dissolve it even before that, then it can be done with the consent of all the partners. If I want to continue even after expiry, then it will be considered as partnership at will. So this is how I try to recall and I try to write and practice. Though a minor cannot be a partner. He can be admitted to the benefits of the partnership, yes. State the rights which can be enjoyed by a minor partner. Okay, again, same. It is similar to what we discussed earlier. Minor can be admitted only with the consent of all the partners. Okay, he can be admitted only with the consent of all the partners. He must be admitted only for the benefits of the firm. He can be admitted only in an existing firm. What are the rights of minor partner? What are the rights? He will get a right to share in the profit and property. Then what else? He will get to access, inspect, take copies of accounts, but not books other than account books. Okay. He can sue the partners if they don't give him the share of profit. Sue the partners if they don't share profits with him. But he can file a case only when he decides to sever his connection with the firm. Sever means he decides to leave the firm. Then have they asked the liabilities? Okay, they have asked the liabilities before and after. Okay, then what are the liabilities? Yes, he has limited liability. It is confined to the extent of his share in profit and property. Okay, then he is not personally liable. Minor turns major. Then within 6 months of attaining majority or the knowledge that he was admitted only for the benefits of the firm, he turns major. Then within 6 months he has to decide whether he wants to continue as a partner or not. So he has to decide whether he wants to continue. Whatever is his decision, he will have to give public notice. If he fails to give a public notice, then he will be considered as a full-fledged partner and he will be liable for all the acts done right from the time of his admission. Now what after majority? What will happen after majority? What are his rights after majority? So his share will remain the same. Okay, rights, everything will remain the same. What about the liabilities? Now he will start being, earlier also he was liable, but it was limited. He was liable only to the extent of his share in the profit and property. If his share was 5 lakhs, he was liable only to 5 lakhs. Now he will be personally liable for all the debts which were incurred right from the time of his admission. Okay, this is after majority. He decides to be a partner. Okay, what if he does not want to be a partner? So his liability will remain the same as that of a minor up to the date of public notice. After the public notice, then he will cease to be liable. Yes. So let's see what all was covered. So minor has a right to share in the profit. He can access, inspect, take copies of the books of accounts. We wrote all this. He can sue the partner, but only when he decides to sever his connection. I wrote that point also. Liability is only to the extent of his share in profit and property. He is not personally liable. Okay. Minor becomes major. Okay, he cannot be declared insolvent. I did not write this point. Cannot be declared insolvent on the firm's insolvency. Liability is within 6 months. He has to decide whether he wants to become a partner or when he gained the knowledge. After that, he will discuss. If he fails to give a public notice, then he will be deemed to have become a partner on expiry of the 6 months. Okay. Rights, liabilities will same. When he wants to become a partner, his rights and liabilities, everything will remain the same as a full-fledged partner. Rights and liabilities, everything will remain the same as full-fledged one. Now he will be personally liable. Share in profit, property, everything will remain the same. If he does not become a partner, okay, he decides not to become a partner, then he has to give a public notice. His rights will remain same as that of the public notice. Now he can also sue because he has decided to sever his connection. Okay, he can also sue. Write in red. His share will not be liable for any acts done after the date of public notice. He is also entitled to. So see, this is how I will write and print. Okay, whether a group of persons is or is not a firm, whether a person is or not a partner in the firm, explain the mode of determining the existence of partnership. How will I decide whether they are partners or not? So see, sharing of profit is an essential element to determine whether they are partners. But it is just a prima facie evidence. It is not a conclusive evidence. Sharing is not a conclusive evidence. We may share profit with our employees also. The relationship of partner depends upon the whole contract. What is the true test of partnership? What is the cardinal principle? It is mutual agency. So mutual agency is the true test of partnership. It is the cardinal principle of partnership. Partner is principal as well as agent. As a principal, he is bound by the act of other partners, and as an agent, he can bind the other partner. We will start by writing what is a partnership. We will write the definition of partnership. Here they have not written, but you may write. So the definition of partnership. Ma'am, how did you understand that we need to write these points, sharing of profit and mutual agency? See, they have written, how will you determine whether these persons are partners or not? Sharing of profit is not a conclusive evidence. Then what is the true test of partnership? Mutual agency. So I need to write about these 2 points. I will also write the definition, although they have not written over here, section 4. I will write the definition also. So this is how I will decide how to frame the answer. What is a partnership deed and what does it contain? This we discussed earlier also. It was one of the question that it should be in writing or it may be oral. Writing is preferred in order to avoid disputes. It should be properly drafted. It should be stamped. It should be signed by all. In case I want to alter any of these provisions, I need to I need the consent of all the partners. So it was discussed earlier. This is a repeat question. You can write over here. It's a repeat question. Next question, Tony and Moni, they are partners. Okay, they admit. Moni. This is a unique question. It's an easy question, but it's a unique question. Just highlight that you need to go through this one day before. Tony and Moni, they are partners. They admit Sony as a partner in new. He is also going to be actively engaged in the day-to-day activities of the firm. There is a tradition in the firm that all the active partners, they will get a monthly remuneration of 20,000, but there was no express agreement. Okay, there is a tradition. It means there is a trade custom or usage. Usage means these are unwritten rules. It's not written expressly somewhere. It's not even in the act. It's not expressly agreed between them, but it's accepted. No salary was given to Sony. He claimed his remuneration, but it was denied, saying that there is no express agreement for that. Whether under the Partnership Act, Sony can claim remuneration. What do you think? Because there is a trade custom, yes. Now what all will we write? The partner is entitled to remuneration, salary, etc. only if there is any express agreement. It means it is mentioned in the partnership deed, or when there is a trade custom or usage. Okay, so here there is a trade custom, there is a usage, so he will be entitled. So partner is entitled to receive remuneration, but this cannot, as such he is not entitled. You can also write that remuneration cannot be claimed as a matter of right. I cannot claim it as a matter of right. It is not my right to receive remuneration. I will receive remuneration only when there is an express agreement, it is mentioned in the deed, or there is a trade custom. So partner can claim a remuneration even in the absence of agreement when there is a trade custom or a usage. So here it is customary, then he can claim even in the absence of the agreement. So since it was customary, he is also admitted as a working partner, he is entitled to remuneration. This is how I revised the entire concept. I will always divide my answer into 4 parts: provisions, facts, analysis and conclusion. So here he can claim remuneration. Mr. Ram and Rahim, they are working. Ram and Rahim, they are working as teacher. This is also a unique question. Please highlight this. You need to go through it one day before exam. Okay, go through this one day before the exam. They are very good friends. They have jointly purchased a flat and they gave it on rent. They purchased flat. See how I write. How I write the facts so that I am able to understand the question in the first reading itself. They jointly purchase a flat and then they give it on rent to John. It was decided that the rent would be 10,000 rupees per month inclusive of electricity. Electricity bill will be paid by the landlord. They by mistake did not pay the electricity bill. Due to this, the electricity department cut the connection. Mr. John has to pay the electricity bill of 2,800 as penalty. So now John is claiming 3,000 from Ram, but Ram says that I am liable only for 1,500. Mr. John says that no, you are partners. I can claim the full amount from any partner. As liability is joint and several. So he's saying because you are partners, liability is joint and several, I can claim that money from any of you. Decide whether Ram is liable to pay 3,000. Are they partners? No, they are not partners. They are only joint owners. Okay, they are not partners. Why? Because there is no mutual agency. They are only co-owners. The rent which they earn is simply the benefit of co-ownership. They are not partners. This is just a benefit of co-ownership. So for a partnership, you need to first define what is a partnership. So they have written the definition. Partnership is the relationship. Ma'am, why have they written the definition? Because I want to know whether they are partners or not. So I need to highlight the elements, no? So I need to write the definition. Because the question is to decide whether they are partners or not. So it must be proved that there is an agreement between all the partners It must be to carry on the business, to share the profits, carried on by also. Can I say that these are the elements of partnership? Yes. So in this case, they cannot be said to be, they are not partners just because they have purchased the flat jointly. There is no business. Okay, this I did not mention. I just discussed the main points. So there must be business. Okay. No business, no partnership. There must be business, no partnership. Yes. So over here, is it their business to purchase the flat on rent, to purchase the flat, give it on rent, purchase the flat, give it on rent? No. There is no business. There is no partnership. There is no mutual agency. They are just co-owners. Rent is merely the benefit of co-ownership. This is not their business. So here Ram is liable only for 1500. That is his share. The other half he will claim from Rahim. So here we also need to write that there is no business. So we will start by writing the definition. We will highlight the elements of partnership. So for elements, you need that there must be an agreement to carry on a business. There must be sharing of profit. Your rent is not profit, it is just the benefit of co-ownership. And there must be mutual agency. Business must be carried on by all or any one of them acting for all. So here there is no mutual agency, they are not partners. So here I also need to highlight business and mutual agency. I need to write that whatever they are earning, the rent, is simply a benefit of co-ownership. They are not partners. So these are the points. This is how I will try to recall all the provisions. Then we have difference between partnership and HUF. Difference you will write in T format with proper head points. These are the points of difference. What is the difference between partnership and HUF? Here there is an agreement. Let's highlight the keywords. This arises from status, that is birth. A person becomes a member of HUF simply by birth. There is no agreement. Partnership is governed by the Indian Partnership Act, whereas HUF is governed by the Hindu law, that is the Hindu Succession Act. They are known as partners. Here they are known as co-partners, and there is one Karta also. He is the senior most member of the family. Here they are equally entitled to take part. Here the right of management is with the Karta or the manager, maybe a male or the senior most female. The liability of the partner is unlimited. Here only the liability of the Karta is unlimited. The liability of the co-partners will be limited to their extent of share in the profits of the partnership. Maximum I can have only 50 partners, but here there is no maximum limit. Minor may be admitted, but with the consent of all. Here minor automatically becomes a member simply by his birth in the family. Death dissolves the firm. Here co-partners' death will not dissolve HUF. Any partner can bind the firm by his act because the partner acts as an agent. Here only the Karta has the authority to contract for the family business. Here the admission, a person can be admitted in an existence with the consent of all. Here it becomes a member by birth. This is a repeat point. Simple points, yes. How will you distinguish between partnership and club? See, partnership is formed with the object of earning profit in a club. Like I started a club for promotion of sports. It's generally not for profit. Object is generally not to earn profit, but to promote art, science, culture, etc. So here the relation is that of principal as well as agent. They are known as partners. Here they are known as members. One member is not the agent of the other members. I cannot bind the other members by my act. The club is liable. Here we can have maximum 50 partners. Here there is no limit. So you have Rotary Club, Lions Club. Here I am interested in the property of the firm because it is my property. There is no distinction between partner and the firm. In case of club, the member has no interest in the property of the club. Property of the club belongs to the club alone. Partnership and co-ownership. In here there is an agreement. Here it may be either an agreement or it may be by operation of law like inheritance. So father died and a very antique painting was inherited by both sons X and Y. Now they are co-owners of that antique painting. Here the partnership is from a business. In co-ownership there may or may not involve business. You're just jointly owning some property, that is also co-ownership. Mutual agency, partners have mutual agency. You're your principal as well as agent. Co-owners, there is no mutual agency. I am not liable for the act of others. Share can be transferred only with the consent of other partners, but in case of co-ownership, one partner may transfer his share. Okay, co-owner may transfer his share without the consent of the other co-owners. X and Y, they jointly own a painting. Yes, X and Y, they own a painting. X can sell his share to A without asking Y. He can also sell his share to Y, thus making Y the whole owner. Lastly, let us differentiate between partnership and joint stock. This was covered in the lectures also. There is no separate legal status, but here there is separate legal status. Liability is joint, several, unlimited. In company, the liability is limited. Partnership, there is no perpetual succession, no perpetual existence. It is affected by death, retirement, insolvency. Here there is perpetual success. It continues till it is wound up. In case of partnership, minimum 2 partners, maximum 50. Here minimum 2, minimum 7. In 2 in private company, 7 in public company. Private maximum 200, public there is no limit. No limit in case of public. Transfer of interest without, you cannot transfer interest without the consent of other partners. Here in a public company, I may freely transfer my shares. I need not even ask the other members. There is mutual agency. Here there is no mutual agency. Partners, they get distribution of profit. Here also they get dividend, but that is not fixed. It is not compulsory. Partners participate in the management. Here members, they don't participate in the management unless they are appointed as directors. Management is with the directors. Audit is not compulsory. Company audit is compulsory. In case of partnership, they are the joint owners of the property. Here they are not the joint owners. In case of partnership, creditors can take action against the partners jointly and severally because there is no separate distinction between partners and the firm. They are not distinct. But in case of creditors of a company, creditors have entered into contract with company which is a separate person in the eyes of law. So creditors can file case against the company, not members. Members are in fact stranger to contract between creditors and company. So creditors can sue the company, not the members. Firm can be dissolved anytime, but here it is a creature of law. It can be dissolved only by operation of law. You have to wind up the company. It must be wound up by operation of. Is it clear? So finally, after all this, you will then consider that yes, your chapter is now revised. See how we revised each and every concept in detail. This is how you will make notes. This is how you will recall, write and practice, compare your answer with the model answer. Whatever you missed out, you will highlight in red. Like I knew this point business, but sometimes, while reading the question, your mind is somewhere else. You may miss out on a point. But this now I will remember till the end that yes, I missed this point. I highlighted that in red. And this is how you will write and practice, and you will eventually learn how to frame the answer. In provisions, let's recap. What will you write in provisions? In the provisions part, I will write the theory along with the section number, name of case law. I will highlight that by drawing a box. Okay, so only theory, section number, name of case law. Then leave a line. Write facts of the case. This you can write in your own words and very briefly. Then analysis. Here you will try to provide some solution. So use the theory plus the facts and offer solution. So it will be a mixture wherein from the theory, from the facts, you arrive at the solution. Lastly, conclude. Okay, this is to end. So, hence, therefore, thus, it is so concluded. From the above, okay, from the above, we can conclude that this is how you will conclude your answer. You will divide your answer into 4 parts. Alright, so I hope you got an idea on how to write the answers, and we also discussed the answer of Unit 1 of the Partnership Act. I will repeat this again when we discuss partnership, but I just wanted to give you an idea. I chose partnership because you have a fair idea. You have studied that in 12th, so you will be able to understand what I am writing. In the beginning itself, you will, gain an idea on how to write the answers, how to learn it. So students, I hope that doubt of yours was clear. Yes, this is how we will discuss all the compiler questions in our regular lectures. So I hope that you got a fair idea. Yes. So let us go through the other discussions also. This may take you 2 or 3, chapters, and after that you will know how to write it. But that effort needs to be taken in the beginning itself. Okay. So let's meet in another session. I'll see you there.